Welcome to the class Conveyancing and Legal Writings, Law 401, Section 1, Week 4, Part 1. I already explained you an attestation is a declaration by a witness that an instrument has been executed in his or her presence according to the formalities required by law. That means an attested instrument must be proved by the attesting witness. Attestation is defined in Section 3 of the Transfer of Property Act 1882. Therefore, it is a condition to complete the formalities for making a valid deed. Indeed, in addition, I also explained that there are some essential elements. One of those is number of attesting witnesses. According to Section 3 of the Transfer of Property Act 1882, minimum 2 witnesses are needed. Maximum number is not mentioned. For this purpose, different law section acts indicates different minimum number. In Law 401, last video I told you, for the purpose of making a gift of immovable property only, the transfer must be effected by a registered and attested instrument by at least 2 witnesses. That means minimum number of attesting witnesses is at least 2. This video we will start with mortgage. According to Section 59 of the Transfer of Property Act 1882, there are 2 parts. First part is where the principal money secured is 100 taka or upwards. A mortgage other than a mortgage by deposit of title deeds can be effected only by a registered instrument signed by the mortgagor and attested by at least 2 witnesses. Therefore, minimum number of attesting witnesses is 2. Second important part is for formal part of essential deed. It is necessary to put the signature of the mortgagor and 2 attesting witnesses. Therefore, it is optional to put the signature of the mortgagee. Next point is will. Section 63 of the Succession Act 1925. First, for your knowledge, an unprivileged will under Succession Act is one that can be created by any individual, which is known as will in our daily family life. The person creating the will must be of sound mind and should have attained the age of majority and not disqualified by law. Otherwise, the will cannot be enforced. As a will is nothing but a legal declaration. Certain conditions must be met with making a valid unprivileged will. Now the question will arise, what is unprivileged will? It is, just for your knowledge, privileged wills are those that can be made any members of the armed force employed in an expedition or engaged in actual welfare and can be made in oral form as well. And the unprivileged will under Succession Act is one that can be created by an individual, which is known as will. That means privileged will made by any members of the armed force, that means army, marine, etc. An unprivileged will can be made by an individual, which is known as will. In this video, I am going to explain what the mode is of making and rules for executing unprivileged wills. First, for attestation, Section 63 of the Succession Act 1925 indicates the will shall be attested by two or more witnesses. That means minimum two and maximum depends on the parties. As for procedure, number 1, the testator shall sign or shall affix his mark to the will, or it shall be signed by some other person in his presence and by his direction. That means testator's signature is mandatory, or by the testator's direction some other person's signature is necessary. Number 2, each of whom witnesses has seen the testator sign or affix his mark to the will, or has seen some other person sign the will in the presence and by direction of the testator, or has received from the testator a personal acknowledgement of his signature or mark, or of the signature of such other person. That means either all the witnesses have seen the testator sign or other person sign, or has received from the testator a personal acknowledgement of his signature or mark, or of the signature of some such other person directed by the testator. Number 3, each of the witnesses shall sign the will in the presence of the testator, but it shall not be necessary that more than one witness be present at the same time. Attestation is necessary for the validity of document, and in practice adopted as the witnesses can be called to prove the execution of the deed when required. The witness must sign for the purpose of attesting the execution. It is not necessary that the attesting witnesses should be made aware of the nature or content of the document. They are merely of the witness of the execution of the documents by the executant. Now, stamp duty. Stamp duty is the tax governments place on legal document, generally in the transfer of assets or property. Government impose stamp duties, also known as stamp taxes, on documents that are needed to legally record certain types of transaction. This includes legal documents recording marriages in the sale or transfer of a property, will, court petition, etc. Historically, governments impose these taxes in order to raise money to fund government activities and projects. These taxes were called stamp duties because a physical stamp was used on the document as proof that the document had been recorded and the tax liability paid. Therefore, in short, tax on legal documents such as those used, for example, for the sale or purchase of shares or the conveyance of a property to a new owner. There are two types of stamp paper used. Number 1, stamp papers which would be used in courts like for payment of court fee is judicial stamp paper. Something which has relation to the administration of justice, judicial papers or stamps are used. That's why judicial stamp papers are also known as court fee stamp paper. Number 2, stamp papers which would be used for execution of document are called non-judicial stamp paper. something with which is related to the transfer of property, commercial agreements, power of attorney, etc. Non-judicial stamp papers are used. Therefore, both judicial and non-judicial stamp paper are the instruments of the state to collect duties from the citizens. Judicial stamp paper are used for paying government dues in respect of a judicial proceedings, while non-judicial stamp papers are used to pay the government due in other legal proceedings such as registration of deeds, swearing in of affidavit, execution of agreements, and so on and so forth. In any case, the revenue goes to the government.